એક વર્ષ ઉપર થઈ ગયું છે, 1.25 વર્ષ થવા આવ્યું છે સાહેબ, અને એમની અસ્થિ વિસર્જન બાકી છે સાહેબ.
આ મુખ્ય આરોપી છે સાહેબ. 16/3 એમના પિતાશ્રીનું અવસાન થઈ ગયું. અત્યાર સુધી સાહેબ અસ્થિ વિસર્જન 16/3, અત્યારે 16/5 થઈ જાય. અત્યાર સુધી અસ્થિ વિસર્જન નો કાર્યક્રમ હોય જ નહીં
સાહેબ. પછી તો
હોય જ નહીં સાહેબ. અસ્થિ વિસર્જન 12 કે 15 દિવસ બધા.
હા, અંદર હતા ને સાહેબ, પછી તો 1-2 મહિનામાં તો અંદર આવી ગયા, એટલે થયું જ નથી.
ના ના સાહેબ.
હરિદ્વાર. હરિદ્વાર.
હું ચોગન
Malu would have paragraph 2 on page number 3. Yes. I'm sorry, Malu. Yes, 2 and 3. 2 and 3. Yes, Malu. 2 and 3 are brothers. They were the directors of the company which had taken loan from the bank. Essentially, Malu, I'll just briefly tell what the issue was. They took loans from various banks. That is the main company, Vishal Export Overseas Limited. The bank, ultimately, the case of the banks is that this amount, though it was taken for a certain purpose, it was misused and it was used for some other purpose. So they filed a FIR. The accused, Paritosh Gupta, Malu. Malu, for 4 and 5. 4 and 5. Well, there was one more application file for accused number 20. For 4 and 5? 4 and 5? Yes. On their behalf. Wakalatnama would be signed by. No, I'm appearing on their behalf. My sign would not be there. I'll do that. I'll do that. If Milo would have paragraph 2 of the complaint, which is the genesis of the proceedings. Para 2, investigation by CBI. Whereas the following FIRs were filed before the Additional Chief Judicial Magistrate CBI, Mirzapur, Ahmedabad, under various sections as mentioned in the table below, against Messrs. Vishal Export Overseas Limited and other accused. Malas would have the table. These are 5 complaints, FIRs, which were filed by 5 different banks. And if my lords would have the name of the accused, the name of accused number 4 and 5 is not there. These are the people who had availed the facility, credit facility from these banks, and the amount is mentioned at column number 5. The total was approximately of 212 crores. Then my lords may have the next paragraph, which gives a gist of on the basis of which why the complaint was filed by the bank. Investigation by CBI revealed that VEOL, that is Vishal Export, and its director and Mr. Patel, director of Wellworth Overseas Limited, entered into criminal conspiracy with each other with the object to cheat Andhra Bank to the tune of rupees 21.01 crores by fraudulently inducing the bank to disperse the credit facilities, dishonestly misrepresenting and submitting the false and forged documents to the bank, and thereafter by misappropriating the sanctioned funds and misusing the fund for the purpose other than the loan had been sanctioned. Now, all the subsequent paragraphs are on the same lines, but by different banks. Now, my lords would have paragraph 3 on the next page. on the basis of these FIRs filed by the bank, the case under PMLA, and whereas on the basis of the said FIR lodged at Ahmedabad in the subject matter, this directorate has registered regular cases under various ECIR. The details of ECIR are added under. Again, my lord would see column 5. It's these 5 ECIRs are filed for separate banks. Again, the amount is same. And if my lord would have the next table on this very page, the names of persons who were found to be guilty or who were alleged to be guilty. Again, the name of accused number 4 and 5 is not mentioned. Then my lord would have the next page, the top paragraph. The investigations under PMLA was initiated and fund flow of loan sanction and utilized was studied. It was found that such money was utilized in a very complex manner. The consolidated summary of loan to the tune of rupees 214 crores approximately was sanctioned by various banks to BUN. The majority of packing credit loan was sanctioned for export of capital. The purpose of the loan sanction and utilized thereof is reflected in the table. Madam, kindly note this table. This will be important because this is the fund flow which is treated as proceeds of crime. They say that money was taken from the bank, but not used for the purpose of, let's say, sale of capital, but it is used for other purposes. These are the other purposes that they have identified. And the first column, summary of utilization of fund of so-and-so bank. Bank, loan repay, brokerage. Yes. It was actually export of various products, not just capital, but it was facilities for export of various products. But their allegation or the bank's allegation was that you did not utilize it for this purpose, you have misused it for some other purpose. This is the misutilization alleged by the bank and relied upon by the indictment, which is bank loan repay, brokerage, purchase of coal, castor, cattle feed, diamond, gold, pharma, rice, soybean, wheat, and windmill. So they identified where the money was going or how it was misutilized. My lords would have the first paragraph at the bottom of that page, Punjab National Bank. I'm sorry, madam? By 5 banks. 5 banks. The distribution of that amount, my lords would have in the previous page at para 3, there's a table. It's actually 212 crores. They have approximately said 214, is actually 212 crores, 0.36. My lord would have the table just below Punjab National Banks. And there is a remark column at the right hand side. It just give a gist of how it was misutilized. The subject loan, were sanctioned for export of agro products, but the same were diverted for other purposes. That is, purchase of gold, farmer products, local letter of credit payments, bank loan fee payment, and other various expenses. Again, the export of diamonds, bill purchase finance was availed and was utilized for the purpose purchase of gold, castle, soybean, so-and-so product. Personal loan repayment of VIL, Himanshu Powder Private Limited, FDR in the name of VUL, crystallization foreign bill purchase, short-term loan was sanctioned for the solution. Ultimately, these are the basis on which how it was utilized, which was not permitted as per the bank. Now, my lord would have paragraph 4.1. The investigations under PMLA revealed that there were multiple interlinked transactions and the loan sanctioned by various banks was utilized for the purpose other than it was sanctioned. From the scrutiny of the sundry debtors of VEOLs, it revealed that there were various debtors situated in India as well as outside India. The verification of major debtors was done, wherein it revealed that either the debtors were not available at their address or were not in existence. It is evident from the same that directors of VEOL had siphoned off the money by way of bogus purchase and sale. In regard of the debtors, this office is already in the process of issuing letter of request. The details of the same is discussed in preceding paragraph. In view of the discussion herein above, the properties were identified and the sources of funds were correlated, and the following provision attachment orders in regard of the immovable and immovable properties were issued. It appears prima facie that the properties has been acquired from the proceeds of crime, and the said fact has been corroborated by confirmation by the adjudicating authority on so-and-so order. So they now in para 4.1 allege that money was utilized for purchase of certain properties. So the money gets translated into property, which is now the proceeds of crime. This is where I come in, because up till now, there is no allegation against accused number 4 and 5. Because in this table at the bottom of this page, two properties are mentioned in the last provision attachment order, that is 10/2014. One is office number 301, Shield Complex, and the third property in that column, that is 409, Chitra Rath Complex. Because in one of the transactions of sale of this property, my name came up, and I will also note the value. Value is 6.5 lakhs and 8 lakhs. Malas would have to repeat himself. Yes. Yes. So then the fund flow is also very, very curious. Malas, see the next page. Because what they try and do, they have first identified the properties which were at some point of time in the name of Vishal Export, and they have treated it to be proceeds of crime. And after that, they try to identify what is the source of fund for that property. Because on first hand, they have actually followed the money, how it was misutilized. So it was never their case that that money was utilized for the purchase of a property. So in my humble submission, this property could never be treated as proceeds of crime. But I am not concerned with that. Malu would have the next page. Para 5. For the property, no, because the property is not with me. I was there was a transaction in between where I paid the money. So they point out the entire flow of funds, and they say that you have paid some amount in between where the property changed hands. Hence, you have handled at some point of time proceeds of crime. No, please have this name of the IMUL property holder. The current holder is Praveen Halvadia, Pragnesh Parikh, and in last column it is J.D. Mehta. So I am not even the current holder of the property. Because the property was sold from A to B to C to D, and somewhere in between I had also purchased the property. So the allegation is that it appears to be the allegation that I had participated in hiding the tainted property. No, it was sold subsequently. So it was one of the transactions in between. I did. Please have the next, please be clear. Please have the next paragraph 5. So clause 8. This is with regards to Shield Complex. During investigation, the statement of Pradeep Mehta was recorded for unearthing the source of fund in regard to the property, that is office at Shield Complex, purchased by Navkar Greens. It revealed that the said property was owned by Pradeep Mehta and Deepak Mehta. The same was sold by them for rupees 6.5 lakhs to Navkar Green in the year 2008. The director of Navkar Green is Mr. Praveen Halvadia, who is childhood friend of Pradeep Mehta, and Shri Pragnesh Parikh, brother-in-law of Deepak Mehta. Navkar Green Power Limited Sonsa had received 6.5 lakhs from Sonal D. Mehta, that is wife of Deepak Mehta, for making payment to Pradeep Mehta and Shri Deepak Mehta. Sonal D. Mehta had received 6.5 lakhs from Messrs. Vishal Plastomer, again a group company VOL. Messrs. Vishal Plastomer had taken amount of rupees 10 lakhs from VEOL, of which 6.5 lakhs was given to Sonal Mehta. Messrs. Vishal Export Overseas had received rupees 10 lakhs from Global Nutrition, who in turn had received rupees 10 lakhs from JMD Media Private Limited. Messrs. JMD Media had received an amount of rupees 5 lakhs on sale of the property situated at 18 Nilraj Industrial Estate to Messrs. Ramesh Kamath. The subject property originally belonged to Messrs. VEOL, which was purchased in auction. It is evident that to save from the clutches, the property was sold to so-called Navkar Green. The chain of transaction clearly establishes that the same was purchased from the front of VEOL, and the front flow chart is available. So what they did, my lords, they tried to follow where is the money coming in for the purchase of the property. Now they have completely disconnected with the banks, because they already found how that money of bank was utilized. They let that go. They identified that this property at some point of time was in the name of Mr. Pradeep Mehta or VUL. Then they try to trace where is this money coming from to purchase this property. And this is the flow of money. On the next page is the flow. Please have the next page. though this is the flow chart is prepared, it will be easier to understand. I am the director of global nutrition products. No. In this flow chart, which is prepared on the next page, Milo could have the name of global nutrition products. It is the third column. There I am the director, Rakesh Bhatt and Falguni Bhatt. Now, global. Now it is very, very curious. Milo could have the first column in that control. The property situated at 18. So this is some of the property. 18 Neelraj Industrial Estate, Andheri, was owned by VEOL, which was auctioned by bank and purchased by JMD Media. This is, my lords, just after the paragraph I read, 5A, on the next page. There is a tabular representation with arrows. Yes, the same property they are talking about. Steel. What in the previous paragraph 5A, my lords, I noted that they ultimately came that the fund was coming from sale of a property called 18 Neelraj Industrial Estate. This is the origin of the money. So the flow chart is in reverse in the next page. That shows how the amount was flowing. Yes, ma'am.
Also similar.
Steel, yes, steel complex. Correct. Right now, para 5A deals with steel complex. Para 5A deals with only steel complex, but the bottom, after tracing the money, they find that the money had originated from sale of a property called Neelraj Industrial Estate. 18 Neelraj Industrial Estate, which was sold to Mr. Ramesh Kamath. Mr. Ramesh Kamath had paid that amount, which ultimately changed hands and which was used for purchasing this property called steel complex. Now, very curious fact is that this Ramesh Kamath is not involved in this case. So the person who had originally paid the amount, according to them, he is not concerned. If that is the case, in between, if the money has flown through my hand and given to someone else, how would I become party to a proceed of crime? Yes. I'll just repeat that. They identify steel complex to be proceed of crime. Now, because steel complex per se does not have any connection with the loan sanctioned by the bank, the exercise that they do is that they try and trace the money with which this steel complex was purchased. And this para 5A is the flow of that money. That the property was purchased for 6.5 lakhs.
These numbers, yeah.
Para 5A, Mother would see 6.5 lakh. The property is sold to Navkar Greens for 6.5 lakhs. So currently, the property was in the name of Navkar Greens. They say Navkar Greens got this property for 6.5 lakh rupees. That 6.5 lakh rupees Navkar Greens received it from was received from Sonal Ben Mehta, who was wife of Deepak Mehta. Sonal Mehta received this 6.5 lakh rupees from a company called Messrs. Vishal Plastomers. Vishal Plastomer received this money from Vishal Export Overseas Limited. Vishal Export Overseas Limited received this money from Global Nutrition, which is the company where I am the director. I received this money from JMD Media Private Limited. JMD Media Private Limited received this money on sale of a property called 18 Neelraj Industrial Estate to Ramesh Kamath. So, if Ramesh Kamath was involved in the original infraction or with proceeds of crime, this flow would make sense. Otherwise, how would this make sense that this becomes proceeds of crime? Because their end point is Neelraj Estate. Neelraj Estate has nothing to do with the proceeds of crime. So if this money has come from Mr. Kamath or Messrs. Ramesh Kamath and company, how is that relevant at all to the original infraction? How is this proceeds of crime? And I'll tell my lords how they jumped this. Please have the next page. The first paragraph, the column, the property situated at 18 Nilraj Industrial Estate was owned by VEOL, which was auctioned by bank and purchased by DMD Media, and purchased on said property, the funds was given by VEOL. This, because my lords will see all other transactions, they have check details, date. This first allegation that VEOL paid that money for that industrial estate, where is this coming from? Absolutely no evidence on record. They realize after going through the entire source that it ends with this property 18 Nilraj Industrial Estate. Now, how do we connect it to VEOL? We'll say that this money was paid by VEOL without any proof. There is only one line which connects this. Because all other transactions Malo will have are payments which are done by check. There is proof on record, dates on record. Other than this single allegation that money was paid by VEOL for purchase of this property. The burden to show that I had dealt with proceeds of crime in any manner would have to proceed first on the basis that these are proceeds of crime. If we come to a conclusion that these are proceeds of crime, question would be that how have I dealt with it? Whether I knew that these were proceeds of crime. In my submission, that first factor itself is not satisfied. How do they show that this property Shield complex is proceeds of crime? It is nowhere connected with the amounts which were disbursed by the bank, and that's the very basis on which the proceedings was initiated. In fact, as per their own fund flow, my lords have seen at page number 6, the utilization of funds is made out by them. And the reason for this is if I am not connected with any of the proceeds of crime, this prosecution will fail against me. Because the only allegation against me is that under section 3, I have in some manner involved myself with the proceeds of crime. According to me, the proceeds of crime and its utilization, they have themselves charted and said that it was misutilized for various purposes, which are purchase of gold, diamond, which may be other things. But for purchase of property, it is not even their case. And when they go to the property and they find out the fund flow, they end with the sale of 118 Nilraj estate, which is sold by a person, Messrs. Ramesh Kamath. How is he relevant to this case? And he's not even an accused. And this is the same case for the second property, which is at page number 12. Page number 11 is the description in words, and the fund flow is at page number 12. Madam, I have page number 11 first. This is 409 Chitra. In regard of property shop number so and so 409 at Chitra, it is revealed that both the properties were purchased by Deepak Mehta from Meena Ben Parikh, who was owning the said property. Shri J.D. Mehta, who is the current owner, my lord, received rupees 12,50,000 from Global Nutrition Product Limited, that is me. Messrs. Global Nutrition Product Private Limited had received 10 lakhs from Shri Mehta. Shri Mehta had received 10 lakhs from Global Nutrition Products Limited. Messrs. Global had received an rupees of 30 lakhs from sale of Hateshwari Om Power Enterprise Private Limited, Shimla, which was a subsidiary of VEOL. Hateshwari Om Power Enterprise Limited was established by VEOL from its fund as a subsidiary company. Hence, it is evident that to save from the clutches of PMLA, the property was sold to so-called Nafka Green. It appears that property that the same was purchased from the funds of VEOL. Now, I will kindly have the next page. All transactions have exact details with check number and date, other than the fact that VEOL had put in some money in this subsidiary. Absolutely no proof for that. The main factor which would connect anything to VEOL, there is no proof on record. Sale of business, a genuine business transaction, money then ultimately flows to Deepak Mehta, who purchases the property. How is this at all connected to the main infraction where BUL had taken money from the banks and fraudulently misused it? That link is not at all there, not even attempted. Now we will have the first paragraph on the fund flow. The only allegation in the first line, Hateshwari Om Power Enterprise, subsidiary of Messrs. Vishal exported overseas at the time of inception. That's it. That's the only connection. Otherwise, these are all banking payments. Please have the gist of allegations against both these accused, which is at page number 39. Para C at page number 39. They have summarized the case of ED against both these accused. Role of Rakesh Bhatt and Falguni Bhatt. Rakesh Bhatt and Falguni Bhatt, who are close relatives of accused number 2 and 3, rendered their name for post of directors, as stated by them in their various statements discussed here and above. Messrs. FFR had received 10 advance foreign inward amount to rupees so and so, where accused number 4 was one of the directors, for export of garments instead of purchasing the raw material for garments. I may only clarify, FFR is not the one who had taken the credit facility. So this is slightly misleading because the case was against Vishal Export Overseas Limited. FFR must have taken money, did business, did not do business, would not matter in this case. If Messrs. FFR had received 10 advance foreign inward amounting to rupees 6.5 so and so, where A4 was one of the director for export of garments, instead of purchasing the raw material for garments, he diverted the part of the said inward remittance for purchased properties and repayment of loan taken from so and so bank. A4 is also a director of Global Nutrition Product Private Limited and Messrs. So and so. The company's firm controlled by Pradeep Mehta is also director in so and so. All these companies in which either A4 or A5 were the director were used for placement, layering, and integrating the POC. This is important, Manoj. This is proceed of crime. A2 had further admitted in his statement that Messrs. FSR software was formed to make software and export thereof, but the company was never produced any software. A4 and A5 have admitted in their statements that the companies were controlled by A2 and E. Though A4 and A5 were well qualified and aware of fiscal laws, they blindly acted on the instructions of A2 and A3 at various stages of process of placement and layering of proceeds of crime without any hesitation, thereby facilitating A2, A3 in placement, layering, and integrating of POC in the financial system easily in such a manner so as to difficult to unearth the placement of POC. This act on part of the accused A4, A5 render themselves liable to contravention under Section 3 of the money laundering, inasmuch as they indulge themselves in using and projecting of proceeds of crime, and thereby the said act on their part is punishable under Section 4. Now, the only proceeds of crime which is connected to me is the property which I pointed out in that table. And in my humble submission, that one, they are not proceeds of crime. There is nothing on record which connects them to the amount which was dispersed by the bank. And two, that even in the fund flow for the property, it has never drawn to the effect that this amount was coming from Vishal. That first property, Steel Complex Malos noted, it came from sale of 18 Nilras by Messrs. Kamath. That has nothing to do with this case. They have themselves, their own investigation proves their case is false. Because they point out the fund flow and they show a proper origin of that fund flow. And in fact, Malos, this matter was earlier also argued, and we had relied on a judgment of and essentially these people got involved because they were relatives of the main accused. I had cited a judgment of Gujarat High Court rendered in the case of Jafar Mohammad Hassan Fattah, where High Court quashed the complaint against the accused who were relatives of the main accused and said that unless the ED brings on record specific evidence to the effect that assuming there is identified proceed of crime, but those relatives are supposed to be aware of the fact that these are tainted properties, and then there is an attempt to hide them. In my case, both the things are not there. Please have this judgment. Paragraph 2. It is undisputed fact that none of these petitioners are arraigned as accused in the scheduled offence, in which after investigation charge sheet had been filed. Therefore, trial of each of these accused petitioners is sought only on the alleged commission of the offence of money laundering as prescribed under section 3 of PMLA. Then the remaining part may not be relevant because one of the arguments they had raised therein was that unless I am convicted or accused of the main offence, this proceedings cannot go on. High Court says no. Even if you are involved only with PMLA, then also you can be prosecuted separately. So that is not my argument. And my lords may kindly have. The argument is at page next paragraph itself, para 3, which is the argument of the ED against these accused. Mr. So-and-so learned assistant solicitor for so-and-so respondent has submitted that present revision is not maintainable at law. He has contended that the amount was remitted to a company where property belonging to his family members were attached, including those of the present applicant of rupees so-and-so in the name of applicant number 2 was attached. Here the property was in the name of that applicant. This have been confirming by the adjudicating authority. He has submitted that properties are involved in money laundering, and during investigation in respect of having knowledge, and they received the payment and made further payment where in their name, and they were signatory and having power to operate account, and thereby they are involved in the case of money laundering. Therefore, it is denied that ingredients of offence are lacking. Now, ultimately, the findings of the court, one would find para 35, 39, 35. Another para 35. This must be cited day in, day out before my lord this time. The same test is applicable in the facts of the press in recent case. By the impugned order dated so and so, the special court for PMLA mechanically took cognizance of the alleged offence punishable under section 4 of PMLA for each of the accused petitioner without even prima facie material showing existence of any mens rea or culpable knowledge with all or any of them of the subject scheduled offence investigated separately by crime branch so and so, or of any proceeds of crime emanating from the said scheduled offence. Neither there is any tangible evidence, nor even any circumstantial material to impute culpable knowledge on the petitioners, and to even prima facie conclude that they were either aware of the commission of scheduled offence or the generation of the alleged proceeds of crime by or out of such scheduled offence. As per the material adduced, it cannot even be prima facie held that the petitioner had any reasons to even have any reasonable doubt regarding commission of alleged scheduled offence and generation of any proceeds of crime in relation thereto. The same is also fortified by the fact that none of the petitioners were made an accused in the scheduled offence. Even though the accused petitioner received in their bank account certain amounts at the instance of or from their close relative Mr. Hassan Patta, the statement, if taken on their face value, do not satisfy even on prima facie basis that the prerequisite for trying any person on alleged allegations of money laundering, that is mens rea or culpable knowledge of scheduled offence and proceeds of crime derived therefrom, and projection of such proceeds of crime as untainted. Even on prima facie basis, no offence is made out against any of the accused petitioner. Therefore, I find merit in the submission made on behalf of the accused petitioner, and I have no hesitation in holding that the impugned order was passed mechanically and deserves to be set aside. In my case, there is only an additional argument that even that property which they identify as proceeds of crime is not proceeds of crime. Here, that was not the argument. It was only an additional step that despite it being recognized in a proceeds of crime, mens rea has not been proved by them. So, well, these are my submissions. That one, that it is not proceeds of crime. Two, there is absolutely no material on record to prove mens rea of the scheduled offence or even that identified property was proceeds of crime.
Sir,
accused number 20 ની પર એક મેટર પેન્ડિંગ છે, ડિસ્ચાર્જ એપ્લિકેશન છે સાહેબ, accused number 20 ની. હા, આ જ કેસમાં છે. હા. In this case, sir, the allegation leveled against the accused has been mentioned in the paragraph I learned friend has read, and their role has been attributed in paragraph C of para 8, sir. And according to that allegation, sir, the accused number A4 and A5 where directors are used to placement, layering and integrating the POC of accused number 2. The accused number 2 has actually generated the proceeds of crime, and these people, both the accused, were the instrument to placing, layering these proceeds of crime in the account, sir. Amount is actually, yes, sir. Yes, sir. Yes. Yes, sir. Oh, sir. That amount, the evidence is that they were made the director of particular companies, and those accounts were actually used. The company were actually floated for the purpose of diverting the proceeds of crime, sir. And the evidence is their statement and a document. And the companies which are formed have not been actually performed their actually purpose of the formation, sir. Yes, sir. Now, sir, so far as the offenses are concerned, sir, this is the offense of presumption, sir. This is mens rea is not to be presumed. It is to be presumed, sir. It is not required to be proved by the prosecution. Section 24 is very clear. The accused has to prove their innocence, that they have not committed the offense, or the amount which was used by them is not the proceeds of crime. Yes, sir. No, I will point. Actually, I will point out the evidence, sir, against them. That, yeah, yes, sir. No. I will point out from the record, sir. Yeah, that is true. No, presumption at the time of deciding the discharge application also, sir. That aspect is to be, because they are asking for the discharge from the case that no offense has been committed. When section 24 applies, sir, then that is also to be considered at the time of deciding the discharge application, sir. That is my first submission. Yes, sir. Yeah. The evidence is that these accounts, they have utilized this account and the money was actually. No. This is, I will point out, sir. No, I will point out from the reply, sir. Yes, sir. The reply has been filed, sir. And in the reply, it has been mentioned. Paranum. Yes, sir. I will actually have to go through the record of the document, sir. No, I don't require time, sir. Yes, sir. Documents I have to point out, sir. Yes, sir. No. Yes, sir. Yes, sir. Yes, sir. The accused number 21 who has filed the discharge application on the similar, there, our role was similar, role was there, sir. Yes, sir. Yes, sir. No. What actually stated in our reply, sir? Yes, sir. Yes, sir. Then the question of presumption would come. No. That is not my submission. My submission is that there is ample evidence that I will point out. Yes, sir. Yes, sir. Yes, sir. Whatever evidence is there, actually in the complaint, the statement of the accused has been referred, sir. In paragraph number accused number 4, sir. That is in statement of Rakesh by Bhatt was recorded on 10/1/2012, wherein he was confronted with the statement of Sri Pradeep Mehta. In the complaint, really they have not given the page number. Para 7, એમાં સાહેબ બધા એક્યુઝના સ્ટેટમેન્ટનો રેફરન્સ છે. પેરા 7. Yes. એ લોકો આપણે આપેલા હા. Further statement. આભાર. Further statement of Rakesh V. Bhatt was recorded on એના આગલા પેજથી આપણે જોઈએ સાહેબ આમાં the company's name is there, page number 20, sir. In it, the statement dated 21/12/2011, Rakesh Y. Bhatt inter year stated that he has resigned from post of director of Messrs. FFR Software Private Limited, and presently he is director of Messrs. Global Nutrition Product Private Limited, so and so place, and Vipal Rasayan Private Limited. He also stated that Falguni Bhatt is dormant director in the following companies mentioned in serial number A and B below, and director in following companies C, D, and E below. In his sales statement, Sri Rakesh Bhatt also stated that FFR Software Private Limited had participated in bidding process done by the State Bank of India in regard of two properties, that is 18 Pasuma Hills, Astapur, Ahmedabad, and 11 Subhas Park, plot number so and so, Ahmedabad. That the payment of which 2.45 crores was made from bank account of Messrs. FFR Software Private Limited for purchase of Vishal Bungalow, and in regard of 11 Subhas Park, plot number 231, Bodakdar, Ahmedabad. The bidding amount of 25% payment was made from bank account of Messrs. FFR Software Private Limited, and Messrs. FFR Software was not in position to make the raised payment. Sri Pradeep Mehta or Sri Deepak Mehta had arranged the person name of Sri Sandeep Shah for making the balance payment of rupees 37 lakh to SBI. On being asked whether he knows Sri Praveen T. Alvaria, he stated that the Praveen Alvaria was co-director of Mrs. FFR Software Private Limited, but he knew him as a friend of Sri Pradeep Mehta. This Pradeep Alvaria happened to be the accused number 6 of this case, and he has passed away, and this case has been actually abated, sir. Pradeep S. Mehta. He also stated that all the family members of the Pradeep Mehta are residing in 18 Vasuma Hill Bungalows. On being asked about the business activities of above mentioned companies, he stated that all the above companies were formed on the direction of Sri Pradeep Mehta and Deepak S. Mehta, and since he is joining the companies as director, these companies have been into fund transfer on instruction of Pradeep Mehta and Deepak S. Mehta to purchase properties put on auction by State Bank of India. Copy of the statement of annexure as E5, sir. Further statement of the Rakesh Y. Bhatt was recorded on 10/1/2012, wherein he was confronted with the statement of Pradeep Mehta dated 27/11 and 3/1/12, wherein he inter stated that both the companies, Vikas Rasayan Private Limited and Global Nutrition and Production Private Limited, were taken over by purchase of shares from one Pinakin Shah, an old friend of Mr. Deepak Mehta. That he knows Sri Praveen Alvadia only as a friend of Pradeep Mehta. Therefore, there is no question of approaching him directly. He also reiterated that remittance and advance against export were arranged by Pradeep Mehta, and the parties remittances only know him, Pradeep Mehta, and that the funds and remittances are used to purchase the bungalow. He also stated that as he and his wife were emotionally attached to Mehta family, but never been a part of VEOL, therefore, they were not knowing the wrong activities of Mehta brothers, and as well as the money was flowing through banking channel. Therefore, they relied upon the Mehta brothers, and that at last they have realized that all that was done for purchasing properties and to enjoy the acquisition and to make more money by selling them on better price to earn good profit. Copy of the statement Annex E6. Further statement of Rakesh Bhatt. After referring to his earlier statement, 27 27/12/2011, he was asked to explain the flow of funds from Messrs. VEOL and Global Nutrition Products Private Limited and Messrs. Vehicle Prasan Private Limited and then JMD Media Private Limited and Mr. LI Hospital Private Limited, wherein he explained the flow of funds for acquiring properties, namely Vishal House and Jai Bungalows, which is depicted at C and D para, and herein above copy of the statement Annex E7. Then statement of Rakesh Bhatt was recorded on 28/1/2013, wherein he was shown the bank statement of number so and so pertaining to Messrs. FFR Software Private Limited with Axis Bank Ahmedabad. In this regard, he stated that all the transactions and credit entries, including cash deposits in his accounts, were done by Sri Pradeep Mehta. That cash transactions, deposits credited in the said account were done as per instruction of Pradeep Mehta only. Copy of the statement, annex of the statement E7. Statement of Rakesh Yagnesh was recorded on 11/27/9/12, wherein he was asked to explain the credit receipt numbers in account number so and so in name of FFR Software. In this regard, he inter alia stated that Mr. FS Software Private Limited was formed at the instance of Sri Pradeep S. Mehta in 2008, and at that time, Sri Pradeep S. Mehta undertook to be consultant for all exports and all related matters. On the next page, sir, statement of Falguni, accused number 5, sir, in para C, sir. Statement of Srimati Falguni, ex-director of JMD Media and LI Hospitality and cousin sister of Pradeep Mehta and Deepak Mehta, was recorded on 4/1/2012, wherein she inter alia stated that she had blind faith on Sri Deepak Mehta and she had accepted become director of following companies on the direction of Sri Deepak S. Mehta, direct of Messrs. VEOL and brother of Sri Pradeep Mehta. That on their direction, she also used to sign the documents of the companies and the checks. Copy of the statement annexed as E9. Further statement of Falguni Rakesh Bhatt was recorded on 9/3/2012, in which one being asked that why she had registered, resigned from companies of Messrs. Vehicle Prasan Private Limited and JMD Media Private Limited and so and so, so and so. She inter alia stated that she had resigned from the companies because she came to know that something wrong was happening. The said company's office of Mrs. FFR Software was searched by Directorate of Revenue Intelligence in 2009, and at that time, her husband Rakesh Bhatt was director of FFR Software Private Limited, and Sri Pradeep Mehta was controlling the company. By this incident, she got the feel that Sri Pradeep Mehta is involved in something wrong. On being asked as she was director of Mr. Vikalp in 2008-9, as to took decision to sell the office at 108 Balram Complex. When said office was sold by Mr. Vikalp Prasan Limited, she stated that on direction of Sri Deepak S. Mehta, she had signed on sale deed and said office and that she is unaware about the buyer also. Srimati Falguni Bhatt further stated that Sri Pragnesh Parikh, who is brother-in-law of Deepak Mehta, Sri Praveen T. Alvadia, friend of Pradeep Mehta, Darshit Mehta, son of Pradeep Mehta, Deepak Mehta, and Rakesh Bhatt, her husband, were other directors of the company in which he was involved as director. Since the above mentioned companies were admittedly controlled by Sri Deepak S. Mehta and Pradeep S. Mehta, Srimati Falguni Bhatt was asked as to why Pradeep Mehta and Deepak Mehta did not become the director of the SECUM. Yes, sir. However, their active participation in the firm which were created, all the firms were controlled by accused, main accused, sir. And they were actually, they have been used for the purpose of namesake, they were directors of the company and they were instrumental in signing the document and operating the bank account, sir. As per the say of the, that cannot be said that they are innocent, sir. And they did not have any knowledge. Knowledge can be actually decided at the time of the deciding the final judgment after the trial, sir. That's why section 24 is being actually utilized for not allowing the discharge application, sir. Secondly, sir, the latest judgment of Supreme Court, sir, where the discharge application of one of the accused of this court, sir, Pradeep Sharma, went to the Supreme Court, where this court has rejected the discharge application. Thereafter, High Court also rejected the discharge application. And while rejecting the discharge application by the Honorable Supreme Court recently, the Supreme Court has observed, sir, that so far as money laundering cases are concerned, thorough trial is necessary. In exceptional circumstances, accused should be discharged. There is compelling circumstances to the court that court has no other choice than to discharge the application, not on this ground, when there is ample evidence, sir. I will give, sir. Paragraph 18 and 9. I thought that judgment is my brief, but that is in another week. Just I will give in the second sitting, sir. That judgment and that actually observation of the Honorable Supreme Court, sir. And sir, so far as Hassan Bhatta's judgment is concerned, sir, that order has been challenged before the Honorable Supreme Court, and Supreme Court has admitted that matter, and it is being, before few days it came for the hearing, but it was not heard, sir. And secondly, sir, on the similar circumstances, the role which was attributed to accused number 4 and 5, accused number 21, Ratna, her application of discharge was rejected by this Honorable Court. Similar circumstances, similar roles, sir. And that order has been challenged before the Honorable High Court, and that order, discharge application order is there, sir. And I will just now, sir, I will give the judgment of Pradeep Sharma case within half an hour, within 10 minutes, sir. And we have submitted the written submission also opposing the discharge application, sir. And so far as Hassan Bhatta's case is concerned, that order is of 2017. Thereafter, the law has been very much clear that if the accused has not been made accused in the schedule of, even though PMLA is being an independent offense, he can be made an accused, sir. Yes, sir. The POC was generated by accused number 2. And see, both the brothers, they have generated POC. And just to layering that, the bank from whom the advances loan was taken and their property were mortgaged, for actually purchasing those properties, they have been used. These two accused have been utilized. They are actually positioned in the firm, though they are not interested. That is their role, sir. They knowingly well that this property does not belong to me, and this property of the accused number 2 and 3, even though those properties are purchased, they have submitted the bidding. That shows their involvement, sir. Who said judgment api do hamna just?
In fact, 24 what Malazwat had observed. Is that paragraph 40 of this judgment? Exactly what the High Court said. That we think 24, first of all, is not relevant for prosecution to the extent para 40 to 42 of that judgment. it says there is no legal presumption that the concerned property is proceeds of crime. One, there is no legal presumption that the person accused has knowledge that the property is proceeds of crime. And three, that the person is involved or is guilty of money laundering. That presumption is for a completely different perspective. It's not for this. Madam, you're right. They have to bring something on record, and then the point would come. Burden would be on me to prove otherwise. So that this judgment was never rendered in the context that because you're not a party to the scheduled offence, you can't be proceeded. In fact, this judgment is in their favor. That even if I'm not a party in the scheduled offence, I can still be proceeded, subject to ingredients of section 3 being satisfied. That is not even my submission. It can't be. If they're able to bring on record evidence to show that subsequent to the offence, scheduled offence, that money came to me or that property came to me, which is proceeds of crime, then it's a matter of prosecution. That's the starting point. That's the starting. And knowledge of scheduled offence. There has to be, because the High Court has interpreted section 3 to mean that I should have either the knowledge of scheduled offence or I should have knowledge of money being generated out of scheduled offence which generates proceeds of crime, and that is in the nature of proceeds of crime which is in my hand. So this twofold knowledge is required to be proved by them. Which in my humble submission there is nothing on record knowledge to bring by.
My discharge applications or accused number 20. For 20. May I complete the arguments if my lords permit? Sought to be made as an accused in a PMLA case merely because she is related to the main accused. And she is the daughter of Subhash Mehta, accused number 30, and sister of accused number 2 and 3. Accused number 20, and she is daughter of accused number 30, Subhash Mehta, and sister of accused number 2 and 3. Next. There are two places where I could find the name of this accused number 20. One is at page number 2, where she is arraigned as an accused, and the other page is at page number 41. Para G. Only two places, subject to my learned friend correcting me, but I have gone through the entire complaint. And only two places mention the name. My lords have got page 41, G, para G, bottom. I just read the para. Role of accused number 13, 16, 17, 18, 19. Now my lords may see 20. A20 is Srimati Rakshabai Mukesh, the present accused. And A21. This is a consolidated government made for these accused. A17, who is wife of A2, and A19, who is wife of A3, had facilitated A9 for the purchase of property situated at 301 Shri Complex, Ahmedabad, by A9 attached white PAO number so and so, dated so and so. A17, A18, A19, A20, and A21 had invested the funds along with A2 and A3, A30 in VRML. Later on, during the investigation, it is evident that VRML constituted from POC, and the same was attached white POA number so and so, and had purchased the property situated at so and so, as discussed in the foregoing para, and received funds from A1, A4, A6, A10, and A12. Therefore, it is evident that all the above accused had knowingly involved in the process of activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, projecting or claiming it as property, and hence made liable for the offence of money laundering. So basically, the allegation is that they invested funds. Now, as far as A20 is concerned, there is nothing on record in the entire complaint, in the entire material, not an iota to show that accused number 20 had at any point of time invested funds in Vishal Reality. No investments made. She is not a shareholder of the company, not a director of the company. He is no way connected with the company in the first place. This is the, in a discharge application, I would be in a position to point out from the complaint itself that not an averment, just a basic simple sentence that so and so accused to so and so accused invested funds. But where is the material also on record and what funds were invested? Nothing is there in the complaint, not a single averment. From the documents also, which will be relied upon, which are part of the record, nothing to show that accused number 20, who is actually a housewife married in 1987, had shifted with her husband to Bombay and now residing in Bhavnagar, had ever invested. I can understand that she was a shareholder of the company, not even that. What, in which manner can an investment take place? She's put in her money, she's one of the promoters, or she's a shareholder. Shareholders basically are outside the, in the sense that the company is run by the directors of the company. Merely being a shareholder does not mean that you become involved in the proceeds of crime and what the company is doing. There is that otherwise also is not the case which is made out in the entire. So as far as the accused number 20 is concerned, her case is much better than the discharge of the other accused which my lords have heard. Because there is no investment, nothing has come to her account, and the proceeds of crime, I will take my lords to the proceeds of crime, nothing coming into her account in the entire transaction. If my learned friend can show that from record, I'll try and confirm. To my knowledge, there is not a single penny which has come to her because she is no way involved with Vishal Reality Overseas. And my lords may kindly see page number 10, where the money trail is mentioned. Funds flow. This is of Navkar Green. She is not a director. She is not a shareholder in the company. Nothing. If I have to take my lords through each and every transaction, her name is in the entire complaint, her name is coming twice in the list of accused and the page which I have chosen. He has no transactions with Navkar Green, which is because in the allegation they said that Navkar Greens has subsequently purchased the property from Shield Complex. So I am trying to even show from Navkar Greens, there is nothing to show that she has invested any money or she received any money. Proceeds of crime have come to her. Page number 16, my lords may kindly see. Formation of Vishal Reality Management Limited. Its allegation is that it was from the proceeds of crime. Fine, today we take it as it is. That's nothing to connect the accused number 2 with Vishal Reality Management Limited. This company was formed in 2006. Vishal Reality Management Limited. Allegation is that it was formed with proceeds of crime. But she is not even a shareholder or a director in that. Nothing. Merely because she is a related person to the main accused. Therefore, her name has been included in the complaint by making a mere statement that some investment has been done. What investment? So at least my learned friend would be in a position to point out that what is the investment which has been made by the accused number 2 in Vishal Reality Management Limited, or that she has received in her accounts proceeds of crime, or she was running this company as a managing director or a whole-time director or anything of that. That aspect is completely silent. As far as the accused number, this present accused number 20 is concerned, her statement has also not been taken. Probably if the statement would have been taken, it would have come forth that how she is involved or not involved, but statement not taken of the accused number 20. And in absence of any details, the name has been included in the complaint. She is not even a party to the original complaint, the original FIRs, is not a party, but obviously that would not make any difference. I have to satisfy the honorable court that as far as this PMLA proceedings are concerned, this complaint has been filed. Now, what is the court? That's page number 25 for a minute, if my lord. These are the details of the shareholders or the directors of Vishal Reality Management. 1 to 10. I do not find the name of the accused number 2 in this. Nowhere. So my submission is that in this kind of a situation where there is nothing to connect this lady who is a housewife who got married in 1987, merely being a relative, is not a criteria for joining someone in PMLA proceedings. PMLA proceedings are serious proceedings. There are serious allegations, and to make her an accused on the basis of no material on record is practically travesty of justice. She is now forced to participate in these proceedings since years. And ultimately, there is nothing on record. Even in trial, there is not going to be nothing on record to show that there is any proceeds of crime which has come to her. She is not connected to proceeds of crime. No money trail comes to her. And judgments which my learned friend had earlier relied upon, they are for arguments, I can adopt that. But as far as facts are concerned, I am in a position to show to the honorable court that she is not remotely connected to transactions which are mentioned in this. If you see the basic allegation is that she had invested in Vishal Reality Management. That is not there. My learned friend may point out on what basis she has been made as an accused this in the PMLA proceeding. But at least to my mind, I cannot find any. So as far as this accused is concerned, she has a much better case than probably the accused whose applications were earlier. One application was heard, my learned friend had pointed out this, but the role is completely different. In that order, it has been categorically mentioned that proceeds of crime had come to that particular lordships. But here there is nothing. And in that matter, there was a joint account. Current account was there where the money was coming, money was flowing out, whatever. Here there is nothing. My learned friend may point out from the record how she is remotely even connected with these transactions. All delegations made without any substantive documents, no material. To keep her connected with these proceedings, my submission would be travesty of justice, and she needs to be discharged.
Para Para 11 of our reply, sir. The role of the accused has been attributed, sir.
There is no reply which has been filed in my matter.
Your reply, sir? Yes.
Reply is not filed in my matter. Maybe a
No.
consolidated.
Raksha Ben Doshi.
There's no copy which has been subscribed.
This was filed in.
कोई signature है?
It's a record man.
We have not been served with the copy of the.
It was filed in 2019, and the copy was given at the time.
Extra copy हो तो वो खाली वांचीने.
મારી પાસે નથી આ એક જ કોપી.
आप वांची लो પછી મને આપો.
પેરા 11 જે છે સાહેબ એમાં રિપ્લાયમાં એમાં our role has been attributed, sir. Page number 4. Applicant was wrongly stated under para so and so that prosecution complaint is silent about her role in offence punishable under PMLA. In fact, para 8G of the PMLA complaint number 6 of 2014 clearly states the role of the applicant that Mr. Vishal Realty Management Limited, in which the applicant is the investor, was constituted out of the proceeds of crime, which stand attached, quite attachment PA number 9 of 2014, dated 31/3/2014. Further details of the investigation statement recorded in connection with the application and our company are also discussed in the complaint. Sir, actually, I have gone through the complaint, sir. Our statement does not actually seems to be recorded. Let me verify from the department whether our statement was recorded or not, sir. No, actually, because she has made an accuser in the case, there must be some substance. If the substance is not there, then I cannot actually pursue the matter, sir. હું આજે જોઈ લો, આજે પૂછી લો સાહેબ. Just let me verify. No, it is not actually. I have tried to find out, sir.
Is mentioned in the PMLA complaint is verbatim reproduced in the para. I see. What they are relying
No,
upon,
no,
the ever
actually-
made the complaint. Anyone's name can be added in this manner in the complaint, just by making an environment.
આજે પૂછી લો. Complete the argument, sir. Yes, sir.
4 માં જોશે. અમો અરજદાર વધુમાં જણાવે છે કે અમારા પિતાનું અવસાન 16/3/24 ના રોજ થયેલ અને અસ્થિ વિસર્જનની તમામ વિધિ મોટા દીકરા તરીકેની અમો અરજદારે કરવાની હોય હાલની અરજી ઉપસ્થિત થયેલ. પછી 5મા પેરામાં ગુજરાત હાઈકોર્ટમાં રેગ્યુલર જામીન અરજી મૂકવા માટે નાણાકીય સગવડ પૂરી કરવાની હોય વચગાળાના 30 દિવસના જામીન. હવે અમારું એફિડેવિટ જોશો ને સાહેબ તો બનાવ બન્યો છે. હવે સાહેબ એમના ફાધર ગુજરી ગયા 16/3/24 ના રોજ. 16/3/24 ના રોજ ગુજરી ગયા અને એમને અટક કર્યા છે 7/6/24 ના રોજ. 16/3/24 ના રોજ ગુજરી ગયા અને 7/6/24 ના રોજ અટક કર્યા. તો ત્યાં સુધી તો એ ઘરે જ હતા. ગમે ત્યારે એમના અસ્થિ વિસર્જન થઈ શકે ને સાહેબ. 3 મહિના, 3જા મહિનાથી 7/6 સુધી. અને સાહેબ બનાવ બન્યો છે 21/5/24 ના રોજ. 5મા મહિનામાં બનાવ બન્યો. 6ઠા મહિનામાં એરેસ્ટ કર્યા અને એ અગાઉ 3જા મહિનામાં એમના ફાધર ગુજરી ગયા. એટલે સાહેબ એ સમય દરમિયાન 4-5 મહિનામાં ગમે ત્યારે અસ્થિ વિસર્જન થાય. અને બીજું એના નાના ભાઈ છે એનું જોઈએ એમનું નામ છે પણ એમના બીજા ભાઈ છે સાહેબ. આમને જ કરું. હા ના એ તો સાહેબ બરોબર છે પણ એના ભાઈ છે બીજા એ પણ કરી શકે ને સાહેબ. વિધિ બધું કરી શકે. જી હાજી 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 એવું જ છે.